How is a breach of contract claim treated? Have you ever wondered what happens when a business faces bankruptcy and has contracts in place? Today, we will discuss how a breach of contract claim is treated in the context of bankruptcy, especially when it comes to executory contracts. In bankruptcy, the way a breach of contract claim is handled depends on whether the debtor decides to assume or reject the contract. An executory contract is one where both parties still have ongoing obligations to fulfill. If the debtor chooses to reject the contract, this rejection is treated as a breach of contract as of the date the bankruptcy is filed. What does this mean for the debtor? They are relieved from any future performance under that contract. However, the non-debtor party, or the other party to the contract, has a claim for damages due to this breach. These damages become a general unsecured claim in the bankruptcy case. This means the creditor may only receive a portion of the claim based on what assets the debtor has available and the bankruptcy plan in place. While the rejection cancels the contract, it does not erase the breach or the claim for damages. On the other hand, if the debtor decides to assume the contract remains in effect. In this case, the debtor must cure any defaults, like missed payments, and provide adequate assurance of future performance. This assumption means both parties must continue to fulfill their obligations under the contract. This protects the counterparty by preserving their rights under the contract and often gives them priority for future payments during the bankruptcy process. The bankruptcy court usually respects the debtor's business judgment on whether to assume or reject executory contracts, unless there is evidence of bad faith. If rejecting the contract benefits the bankruptcy estate by reducing burdensome obligations, the court is likely to approve that decision. For creditors or contract counterparties, there are some key points to keep in mind. First, they cannot immediately terminate or sue for breach once bankruptcy is filed due to the automatic stay. They must monitor the debtor's decision to assume or reject the contract. If the contract is rejected, they should file a claim for damages in the bankruptcy case. If it is assumed, they may require the debtor to cure any defaults and provide assurances before continuing performance. Additionally, some contracts cannot be assumed, such as certain promises to loan money. Breach of contract claims that arise before the bankruptcy filing fall under the jurisdiction of the bankruptcy court and are addressed within the bankruptcy process. This can affect the confirmation of the debtor's reorganization plan. Understanding how breach of contract claims are treated in bankruptcy can help both debtors and creditors navigate this complex situation. Whether a contract is assumed or rejected plays a significant role in how claims are handled, and being informed can make a difference in the outcome for all parties involved.